Welcome back to Government Information Gathering with Mike DeBliss. It's my pleasure to have you back here with me in what is the fifth and final webinar in the series on Government Information Gathering. And what a topic I have for you today. This topic is hands down one of the most enthralling topics in the entire Government Information Gathering series. It's on international evidence gathering. There is no topic that's more relevant to what's going on today than international evidence gathering. As I'm sure you can tell, this is an area that I am very passionate about, and I am so excited to share with you my knowledge on this topic. I can guarantee you that you will get a lot out of this and that you will find it every bit as interesting as I have. Before we jump into the topic, I have to make a little confession to you. I'm a little bit nervous. And I'm nervous not because of the presentation that I'm doing in this webinar, but because of something that I found out a little earlier today as I was driving to my office. As some of you know, I perform on an improv team in New York City at a popular improv theater. Our group is called Bottle Rocket. And there you can see a picture of some of my teammates posing for a photo last summer. Well, our team performs on Saturday nights at the theater. And today is Saturday, so tonight is no exception. We have a show scheduled for tonight. Well, as I was driving to my office, I got a call from one of my teammates who told me that there was going to be a very special guest who would be performing with our group tonight. Now, this is nothing unusual. From time to time, we have special guests that come to perform with us, usually from other house teams at the theater. However, this guest was unlike any other that we've had perform with us. Well, when I tell you who it is, you might be as surprised as I was. It's none other than Tina Fey. So, in the last hour, I've learned that my group will be performing with Tina Fey, and that there is a very good chance that she'll be my scene partner in a number of scenes tonight. So if you hear my voice breaking a little bit during this webinar, you will know why. I am already shaking like a leaf right now in anticipation of what is to come later tonight. Without further ado, let's jump into our topic of international evidence gathering. Now, let's provide a little bit of background information. Today, in the 21st century and in 2015, most companies, regardless of whether they're in the US or overseas, are international, meaning they have customers that are not just local, but that transcend country borders, and they're dealing business with customers internationally. And this explosive growth of international business has been accompanied by an explosive growth in tax fraud across international borders. Very simply, tax fraud is becoming more and more international. Now, you and I are both familiar with tax fraud in the domestic sense. We see headlines for the Department of Justice investigating and bringing prosecutions against U.S. citizens for tax evasion and tax fraud all the time. But we are now seeing this explosion in growth of international tax evasion cases. And that's because there are complex tax evasion schemes that have cross-border aspects. Now, we can't talk about international tax evasion without talking about the special of the day in the IRS. And that is this whole concept of U.S. citizens that are parking money abroad. As many of you know, these U.S. citizens are target number one on the IRS's hit list. And the IRS treats most, if not all, taxpayers who have money abroad as tax cheats who are trying to avoid paying U.S. taxes. But as we all know, there are legitimate purposes for a U.S. taxpayer to have money overseas and to have a foreign bank account. And we're going to get into that very shortly. Now, sometimes a foreign jurisdiction is just as interested in having U.S. cooperation to prevent evasion of their tax laws as the U.S. is interested in having the foreign country's cooperation to prevent tax evasion. But some countries are active enablers of international tax evasion. These countries have staked a significant part of their economic future on benefiting from international tax evasion. Now, the IRS wants foreign financial institutions to disclose the names of their U.S. account holders. Sometimes foreign countries are all too happy to cooperate, other times they aren't. And again, we're going to get into a robust discussion of this in this webinar. So, what are the main methods for obtaining foreign evidence that the IRS uses? They can be reduced to 5. The first is the traditional method. And by traditional method, I'm referring to summonses and subpoenas. But note that I'm referring to summonses and subpoenas in an international context, meaning a summons or subpoena that is issued to a foreign bank. Number 2, mutual legal assistance treaties, or MLATs. Number 3, tax information exchange agreements, TIEAS, and income tax treaties. 4, letters rogatory. 5, none other than FATCA, the 800-pound gorilla in the room. Before we talk about the first 4, you should know in advance that they have major shortcomings. And I'll address those shortcomings in when I deal with each individual topic. So, the traditional methods. This tends to be the U.S. government's first resort. If a foreign financial institution has a branch in the U.S., the IRS may serve a summons or subpoena on that U.S. branch. If the U.S. branch fails to respond to the summons or subpoena, then they're subject to contempt sanctions. What are some of the arguments that you might anticipate a foreign bank to make in response to a summons or subpoena? This is an interesting question, and a lot of people find the answer to be shocking. But here's what it is. Some foreign banks think that the amount they have to pay the U.S. government for violating its laws is less than the economic benefit from facilitating tax evasion. In other words, they view it as a cost of doing business. And what do I mean by the amount they have to pay the U.S. government for violating its laws? Well, keep in mind that when assuming that the U.S. government has jurisdiction over a foreign financial bank, which which it does have if the foreign financial bank has a U.S. branch. If the U.S. government issues the U.S. branch of a foreign bank a summons, and the U.S. branch thumbs its nose in the face of the U.S. government, what is the U.S. government going to do next? Well, they're going to go to court. And when they go to court, they're going to ask the judge to enforce the summons for whatever documents they seek. And that's because, of course, a summons is not self-executing. It has to be, it gets its teeth from the judge ordering that the recipient comply with the summons. So we're now at the stage where the court has ordered the foreign bank to comply with the summons. Assuming that the foreign bank still refuses to comply with the summons, the Department of Justice can go back to court and ask the court to impose sanctions. And that's how we get to this whole concept of money having to be paid. And this is where we get to the whole concept of the economic benefit and of this weighing of paying penalties versus not complying, versus complying rather. And as I mentioned, most banks view the penalties that they have to pay for not complying with the summons as a cost of doing business. Now let's think about this from the foreign bank's perspective. International banking laws, such as those in Switzerland, were once extremely protective of client anonymity. As we all know, Switzerland was a haven for bank secrecy. They are hands down the paradigm for bank secrecy laws, ironclad bank secrecy laws. Anyone who revealed details of a client account in Switzerland could be charged with breaking those same secrecy laws and then be prosecuted and, if convicted, sent to prison. It was the equivalent of treason. The chief argument raised by Swiss banks was that the U.S. government was attempting to force them to break Swiss law by disclosing U.S. account holder information. Until FATCA went into effect, this put Swiss banks and bank personnel between a rock and a hard place. Think about it. What were these bank managers supposed to do? On the one hand, the U.S. government demanded that they produce the names and account holder information of their U.S. customers. On the other hand, if they did just that, they were breaking Swiss law. And what were the risks of breaking Swiss law? A, they could be prosecuted, and B, if convicted, they could go to jail. This was something that this was a no-brainer, an absolute no-brainer for them. They simply weren't going to take one for the team. And so this is why a lot of Swiss banks and managers at Swiss banks that were issued summonses by the U.S. did not comply with them. And as we talked about before, in order for the summons to have any teeth to it, the government had to go to court and get the U.S. District Court to order the recipient of the summons to follow it. And so the U.S. District Court was called upon in many cases to resolve these conflicts. And in doing so, they had to balance the equities to decide whether or not to enforce the summons or subpoena. Now, here is an interesting observation. As I've been talking about the traditional means, you might have noticed something subtle. What was subtle about it is that I was referring to it in the past tense. And that's because the traditional means of summonses and subpoenas is not as common today as it was several years ago. And one of the reasons why is because of FATCA. Nonetheless, it's still an important international evidence gathering tool. The second international evidence gathering tool is the Mutual Legal Assistance Treaty. So what the heck is a Mutual Legal Assistance Treaty? Well, it's a special treaty that is specifically designed for tax enforcement in which countries bilaterally pledge to assist each other in information gathering to deal with tax avoidance and evasion. The key or operative word here is bilaterally. So that contemplates that there is an agreement in place and cooperation between the two countries for this to happen. And as you might imagine, that's easier said than done. Now we are into the third international evidence gathering tool, and that is tax information exchange agreements and income tax treaties. I sometimes group those two together. So what is a TIEA? You've probably heard this acronym tossed about at some point during your practice. TIEA is an agreement that specifically provides for mutual assistance in criminal and civil tax investigations. This assistance includes obtaining foreign-based documents, including bank records and testimony. They are creatures of the Internal Revenue Code. Now, how about income tax treaties? Well, we're all familiar with them. They include information exchange and administrative cooperation provisions. Now, the combination of these mutual legal assistance treaties, these tax information exchange agreements, and standard tax treaties are all dependent on international cooperation. And as you can see here, the caveat is they exist only if the country is interested in signing such an agreement with the U.S. And as I mentioned before, that's easier said than done. Of course, there are some partners that the U.S. has that they can traditionally rely upon in participating in treaties and engaging in treaties with. You don't have to think too hard to know what countries they are. The UK, of course, comes to mind, as well as other countries in Central Europe. But there are just as many other countries that would rather not enter into an agreement with the U.S. for international evidence gathering. Letters rogatory. That's our next evidence gathering tool. What the heck are they? Well, they are an interesting creature. At their core, it's a technique where a U.S. federal court transmits a request to a foreign court, asking the foreign court to provide assistance with respect to an ongoing matter in the U.S. court. Wow, what a mouthful here. What a mouthful. So what we're dealing with right now is we're dealing with the courts, and the courts as facilitators of exchange of information. And, at its core, the U.S. federal court is requesting a foreign court to turn over specific information. And this is based not on any treaty obligation, but it's based on comity. And when I refer to comity here, I'm not referring to comedy as in the case of improv comedy. I'm referring to this concept of professional courtesy. This comity is spelled C-O-M-I-T-Y. So what's happening here is that the U.S. federal court is transmitting a request to a foreign court for specific information about for specific information that the U.S. government is trying to obtain from a company within its borders. The U.S. federal court transmits this request through the U.S. State Department and through the foreign ministry of the foreign country. But at the end of the day, it's up to the foreign court as to whether or not it will honor the U.S. federal court's request. Translation: the foreign court will do it if it feels like it. In the rare case that it feels like it, it can take forever. Now for what we've all been waiting for. The Foreign Account Tax Compliance Act, FATCA. As I mentioned earlier, this is the 800-pound gorilla for international evidence gathering. Well, let's provide a little bit of background information about FATCA. Recognizing that there is a substantial amount of money stored overseas that has gone unreported and that will continue to go unreported if left up to the taxpayer to voluntarily disclose, Congress passed FATCA. It is sometimes referred to, it has been referred to in so many different ways, but one way that struck me as being so profound was the label, the most influential law that nobody knows about. And that really can be used to summarize FATCA. What does FATCA require? It requires foreign financial institutions, known by the acronym as FFI, to report specific information regarding their U.S. account holders to the IRS. Why was it passed? Well, it was passed to clamp down on the use of foreign bank accounts by U.S. taxpayers to hide money that was otherwise subject to taxation in the United States. FATCA is the U.S. government's newest enforcement tool in the fight against international tax evasion. Now, let's, right from the get-go, clear up a major misconception. And I can't tell you how many times I have to clear this up with clients that call and that have questions about FATCA. First and foremost, it is not illegal for a U.S. taxpayer to have an overseas bank account. And by the way, I, under no circumstances, blame the client for believing this. This is unfortunately due to the climate that we live in today, and this fear, fear-mongering that is taking place. So it is not unusual for a lot of people who have foreign bank accounts to be misled into believing that it's illegal to have an overseas bank account. As I mentioned before, overseas financial accounts are maintained by U.S. taxpayers for a variety of legitimate reasons. So let's talk about some history here. If the average American that owns a foreign bank account isn't a tax cheat, what might be his reasons for having one? Well, there are a number of reasons, but what I've done here is I've tried to group them into three primary reasons, and I'm sure that all of you out there can probably think of another 6 or 7 more, if not another dozen. Reason number one, in the not too distant past, wealthy Americans and wannabe wealthy Americans found it convenient and fashionable to put much of their wealth in offshore financial institutions. Although it was not the only player in this game, Switzerland attracted much of the American wealth which was banked offshore. Now, there are many countries in the Caribbean as well as Israel who were more than willing to provide this service, but Switzerland was the biggest name in the industry. Reason number two, convenience and access. In this global marketplace, many U.S. citizens have relocated abroad. And this is, again, for a number of reasons. There are U.S. citizens who work for international companies that have been transferred from the U.S. to a foreign country. There are U.S. citizens who have found opportunities abroad to start new companies and have moved overseas. Now, think about it from a very practical aspect. When you are living somewhere, you need to have access to your money. Now, we can think about it in terms of our in local terms, where if we're traveling on business within the United States, chances are we're going to be able to find another branch of our bank in the in this area, in whatever state we're traveling to on business. One example that comes to mind is Wells Fargo. Let's say you bank at Wells Fargo or PNC Bank. Well, you'll have very easy access to your money if you're making a trip to another state for business. But let's talk about the taxpayer that finds himself living in a foreign country, not just for a week or 2 weeks, but perhaps for a number of years. That person has to have ready access to his money. And so what is the next logical step? It's to open up an account with a local bank in order to conduct day-to-day affairs. It's an absolute necessity. That's the only way that the person will be able to pay rent, pay his phone bills, insurance, Wi-Fi, electric bills, buy groceries, and so forth. Cash is king. You must have ready access to cash wherever you're living. The third reason, many taxpayers have inherited a foreign bank account from a relative back in the old country. That is a very common scenario. Here is the problem. The U.S. taxes its citizens on their worldwide income, regardless of where it is earned. So if you own a business in Sri Lanka, you must report the profits on a U.S. tax return. If you work for a Belgian company in Costa Rica, you must report the earnings on your U.S. tax return. The rule is that U.S. taxpayers must report all of their income, even income earned outside of the United States. Now, When we talk about income here in the context of a foreign bank account, what exactly are we talking about? Well, we're talking about the interest generated on the principal in that foreign bank account. So we all know that when we have money in a bank, it's going to grow, and that there's going to be interest that is earned on the principal. Now, in today's age, the interest is negligible. It is very, very small. However, that interest is taxable, and that is why foreign bank accounts are target numero uno on the IRS's list. Now, prior to 2010, many individuals with overseas accounts failed to mention this fact when they filed their 1040s. They also failed to file a foreign bank account report to disclose their foreign account. Now, the acronym for a foreign bank account report is FBAR, and I'm sure that you have all heard that acronym before. It is very commonly used, and if you were to Google it, you'd probably find close to a million articles on the topic. What exactly is the FBAR? Well, it's a tool that's used by the government to identify persons who may be using foreign financial accounts to break U.S. law. The information contained on an FBAR can be used to identify or trace funds used for illegal purposes, or to identify unreported income maintained or generated abroad. An FBAR is a creature of the Bank Secrecy Act, and that might be very basic to some of you. As I've come to realize in the years that I've been consulting with clients on FBAR reporting, many clients have done an inordinate amount of research and are very well informed about the topic. So this is something that most people know right out of the gate, that it's a creature of the Bank Secrecy Act. It is not a creature of the Internal Revenue Code. And the FBAR is not something new. It's not something that just came out of thin air. It's actually been on the books since time immemorial. Those of you who are familiar with the Bank Secrecy Act know that it was passed several decades ago. And because the FBAR grew out of the Bank Secrecy Act, it was on the books. It has been on the books just as long as the Bank Secrecy Act has existed. Now, the Bank Secrecy Act gives the Department of Treasury the authority to collect information from U.S. persons who have financial interests in or signature authority over financial accounts maintained at foreign banks. So who must file an FBAR? A U.S. person must file an FBAR. And by the way, this is the rule for FBAR reporting. And I want to preface this rule before I state it by saying that virtually every word in this rule is a legal term of art, meaning it has a precise meaning. So it's very tempting sometimes to inject your own interpretation of what a common term in a legal rule means, and that is very dangerous, because what your definition might be for a legal term in a legal rule is quite different from the interpretation that courts have given to it. And trust me when I tell you, the terms in these legal rules, even just a single term, sometimes is the cause for an inordinate amount of litigation and numerous cases written on it. So this is not a topic, this is not something to be taken lightly. And like I said, the biggest danger is the fact that some of the terminology in these rules are very common in regular vernacular speech, and so it's very easy for us to interpret them according to their basic meaning, as we know it. But again, it's so important that you know how the courts interpret the meaning of every single term in these legal rules. So who must file an FBAR? A U.S. person must file one if that person has a financial interest in or signature authority over any financial account outside of the U.S. and the aggregate maximum value of the account exceeds $10,000 at any time during the calendar year. Now, we could spend another 2 hours dissecting this and going into the elements of all of the key terms in this rule, from U.S. person to financial interest to aggregate maximum value to any time during the calendar year. We could spend a long time on that. However, that's not the purpose of today's webinar. So I'm going to leave you just with this definition, but in a future webinar, we will dissect this rule. Now, the government did not begin enforcing FBARs with the level of gusto that it's been doing today until after 9/11. What are some of the reasons why the average American living abroad did not report their foreign bank accounts to the IRS? Well, the reasons that I'm going to give you here are, it's only a partial list, of course, but it's the ones that I run into most frequently in my consulting of clients with foreign bank accounts. Some taxpayers simply didn't know what an FBAR was, let alone that it applied to them. These folks didn't know that they had an obligation to report their foreign income on a U.S. tax return. For example, many thought that they had satisfied their tax obligations merely by having reported their foreign source income on a foreign tax return and paying taxes to the foreign government. That is one of the most common explanations that I'm given when I am consulting with a client who has an unreported foreign bank account. They'll tell me, Mike, what do you mean I had to report this foreign bank account? I reported it to the government. I reported it on my international tax return in the foreign country that I was living in, and I paid taxes on it. Notwithstanding that, there is still an obligation to disclose the account. And again, that stems from the fact that in the United States, U.S. citizens and residents are taxed on their worldwide income. Now, the second reason why the average American living abroad didn't report their foreign bank account. Some knew exactly what their U.S. tax obligations were. So let's not beat around the bush here. Some knew exactly that they had an obligation to report the account, but thought that it was unlikely that the IRS would ever know the difference. And just to expand a little bit on this reason, what many people will tell me is this. They'll say, look, this foreign account earned such a small amount of interest, maybe 2% interest at the most. At the end of the day, the interest that was generated by the principal was so light, and that it would have resulted in negligible U.S. tax. And when you take into consideration the foreign tax credit, there was going to be no U.S. tax liability whatsoever. So what is the point? What was the point of reporting the foreign bank account? Once again, that is a very common reason or explanation that I'm given by clients that I consult with. And the response that the IRS would make to a statement like that is this. They don't care how light the interest income was. They don't care if at the end of the day there is, after taking into consideration the foreign tax credit and whatever other credits that the taxpayer is eligible for, that the U.S. tax liability results in zero. The IRS doesn't care. So this is something that this is a belief that many taxpayers still have, and that we as tax attorneys have had to disabuse them of. So what is it about this pestilent FATCA law that engenders such strong emotions? Let's look at this from the perspective of the foreign bank, and then let's examine it from the perspective of the U.S. taxpayer with a foreign account. First, the foreign bank's perspective. It turns, this law, FATCA, turns foreign banks and foreign financial institutions into enforcement arms of the IRS. This allows the IRS to make sure they're collecting every possible dollar from U.S. taxpayers who have offshore assets. Although the banks seem to have two options, and by two options, here's what I'm referring to. One, disclose account information on clients who are U.S. persons, or two, pay a whopping 30% of all payments they receive from America to the IRS. So although the banks seemingly have these two options, most would argue that there is only one real choice. And there's only one real choice if they want to be around long enough to report next year's quarterly earnings. What is that choice? To succumb to Uncle Sam's heavy-handed demands and turn over U.S. account holder information. Now let's examine this FATCA from the perspective of the U.S. taxpayer with foreign accounts. More than just one taxpayer has come out and been very outspoken about the fact that the government is treating every taxpayer with a foreign bank account as though they are Al Capone, meaning they are branding every taxpayer who has not reported a foreign bank account with the scarlet letter. And that's just not the truth. As we all know, there are a number of reasons why a taxpayer with a foreign bank account may not have reported it, and they are legitimate reasons. So, why is this? What is this about? Why? How has this been perpetuated? Well, or what is the reason behind um, taxpayers feeling like they have been singled out and treated like Al Capone? Well, the IRS is very heavy handed when it comes to punishing taxpayers with unreported foreign bank accounts. And what do I mean by punishment? Well, the IRS often imposes penalties, FBAR penalties, that are so exorbitant that it could leave the taxpayer with nothing more than the shirt on their backs. For example, a willful FBAR penalty. A willful FBAR penalty could be the greater of $100,000 or 50% of the closing balance in the account as of the last day of filing the FBAR. Now, as we all know, this is the ceiling. There is what's called the penalty mitigation guidelines that have various other penalty structures. And the penalty structure for both willful FBAR penalties and non-willful FBAR penalties are dependent on A, whether the taxpayer is eligible for the penalty mitigation guidelines, and B, the high account balance in the foreign account during the course of the year. So those two variables affect what the exact FBAR penalty would be. But what I'm merely doing right now is providing you with the maximum potential willful FBAR penalty to illustrate how punitive the penalties are for somebody with an unreported foreign bank account. And again, this illustrates the maximum willful FBAR penalty and not the non-willful maximum FBAR penalty, which is $10,000. I'd also like to preface this by saying that FBAR penalties are assessed per account and not per year. So if a taxpayer has multiple foreign bank accounts, that could translate into multiple FBAR penalties in a single tax year. As you can imagine, that could drive a taxpayer's FBAR penalty liability into the stratosphere. And this is why the average American, feels as though they are being branded as with the scarlet letter and being treated unfairly by the IRS. Here's an interesting question to ponder. As more countries are pushed to the brink to share tax information through FATCA, the focus now will shift to America's willingness to reciprocate. And who can forget that expression, what's good for the goose is good for the gander? Is this hypocrisy? Well, at present, the U.S. does not provide foreign governments with the same detailed information about their residents who bank with U.S. banks that it requires foreign financial institutions to provide about U.S. citizens who bank with foreign banks. So at some level, there is hypocrisy going on here. The U.S. government is essentially asking foreign governments to do something that it hasn't, or that it's not willing to do. Here's an added bonus that I have for you. This deals with a special a special a special problem, a hypothetical that was specifically designed to test for you to test your problem-solving skills and your understanding of these rules as they relate to international evidence gathering, to a set of facts. And as many of you know, my motto here is learning by doing. By unquestionably, reading and studying a topic will help you understand it. But unless you actually do something, unless you actually walk through a tax problem to see if you can identify the issues and apply these rules to a set of arbitrary facts, will you know how well you truly understand the application of these rules. And this is truly where the rubber meets the road. So this is where the hypothetical lives. And I apologize for the lengthy URL. I wish there was a way to just give you a quick link, but I am planning on making these slides available to you independently of the webinar, so that you have the opportunity to go through them, digest them at your own pace, and then take stock of all of the links that you see here, because there are some additional ones coming up. Here are some other helpful resources. Again, most of these are articles and blogs that exist on my tax blog, which is called Tax Chat. And again, I will make these slides available to you. As many of you know, I've recently launched a podcast, and we are now up on iTunes. The goal is to try and record at least one podcast every 2 weeks. It might be a little ambitious. Only one is up right now, but there are certainly a number of issues to talk about, and no lack of content. So if you have any suggestions for tax podcasts, let me know. I have a few of my own that I've been thinking about, and that I think would encourage a lot of good, robust discussions, especially in the area of the IRS's voluntary disclosure program and Streamlined. Finally, this is my new ebook. I've recently published an ebook on foreign asset reporting, navigating the choppy financial seas. And there's a very special giveaway here for the first 20 to respond. If you are among the first 20 to respond, you will get a free copy. I encourage you to go to my Facebook page at facebook.com/taxwarrior. In the left-hand corner, there's an app that you can click on. It says welcome, and you'll be able to sign up for the free ebook. And again, if you're one of the first 20, you will get a copy for free. Finally, if you have any questions about anything that we've covered in this webinar, and not just this one specifically, but any of the other modules going back to the very first one, please feel free to reach out for me. I love to hear from readers, and from readers of my blog, and from viewers of webinars. Don't think that in any way, shape, or form you're disrupting me. I love this. I love this engagement that we have through social media. So you can call me, you can email me at mjdebliss@deblisslaw.com, or you can go to my website and take a look at some of the blogs that are up there. And I look forward to hearing from all of you, and There will definitely be some future webinars covering other issues that relate to many of the topics that we've talked about and that relate to other topics outside of government information gathering. So stay tuned for what is to come. Thank you for taking the time to to listen to these presentations and these webinars. It took a lot of time to prepare them, and I hope that you got a lot of value out of them.